I'm so happy to join with me, along with my colleagues, State Representative Mary Isaacson. And I just want to say thank you, State Rep, for having me on and hosting this event.
Well, thank you so much, Madam Register Gordon. We're so honored to have you, that you would present such vital information to the residents of the 175th tonight. And thank you also to Tasha Little for helping us coordinate this great event. This pandemic has brought so much financial uncertainty to far too many households and caused too many of us to step back and review about whether or not we have all our papers in order. This seminar tonight focuses on planning, preparing, and protecting our futures, as well as generational wealth, could not come at a more critical time for us. Many of us have not reached out to the Register of Wills office, and it's imperative to know about their services, and far too many Philadelphians lack a will or estate planning. The Honorable Tracey Gordon is known for her commitment to ensuring that every citizen understands the importance of wills and creating a level playing field when it comes to future generations, even if it's only a home you have to leave behind for somebody. She's also committed her office to address legal problems with home ownership, often known as tangled titles. Tangled titles are a huge problem here in Philadelphia when it comes to transferring wealth, and many people may not even know they have this problem or assume that everything is in order. However, you could have a tangled title or home ownership problem if your name is not on the deed of your house, you do not know if your name is on the deed of your house, the city or a utility company has refused to discuss unpaid taxes or bills with you because your name is not on the deed to your house. The city has refused to give you a grant to repair your house because your name is not on the deed to your house. One of your relatives owned the house in which you lived in and has his or her name on the deed, but that relative has passed away. You are the only person with an interest in living in that house, but your name is not on the deed of your house. Or you enter into a rent-to-own agreement to buy the house and have paid all or some of the purchase price for the house, but your name is not on the deed of the house. As Register Gordon and her staff will discuss, they offer services including but not limited to receipt of wills for probate, that's the legal process for transferring property of deceased individuals to their heirs, issuance of letters of administration in case of a person who has died in state, collection of inheritance tax due to the Commonwealth, duplicate old probate records, issuance of marriage license, and duplicating old marriage licenses. So that's just some of the services that the Register of Will can provide to you. And we're happy to be able to provide this webinar so that we can make sure that people are informed in what they can have done for them by the Register of Wills. Now I'll turn this over to the experts to discuss the services and more. And thank you for all of this, and let's get ready to take some notes.
Yeah, wow. You know what? We might hire State Rep Mary Isaacson to do some of our Plan, Prepare, Protect webinars. And the Plan, Prepare, Protect is simply, we want you to plan your estate, prepare your heirs, so you can protect your assets. And that's why we entitled this series, because what we're finding here in Philadelphia is an epidemic of, like you said, tangled titles, but mainly because people do not understand the importance of making wills. They don't understand the importance of when they make their wills, and they don't understand the importance of telling somebody where their will is. Because a lot of times you think that you make your will when you get old, but you are not guaranteed to live to be old enough to make a will. Something suddenly could happen, like COVID-19.
Yeah.
Or you think that your will, or you don't need to make a will because you don't think you have assets. You might think that automatically, I only just have one house. Why should I, have a will? Automatically it will go to a spouse, which is true. But if you don't have a spouse, You can say, well, my kids can figure all that out. And as a result of just taking it lightly like that, it causes a lot of problems and a lot more money when you pass without a will and intestate, and then you come, your kids go to a realtor and think they can sell a house and find out that they have to come to an office that they never heard about. And a lot of times people hear about the register of wills when there is a tragedy or a death in the family. And what I want to do is to educate the citizens of Philadelphia before that happens so you can be prepared. So you can take the time to go to an attorney, which we recommend, have them write out everything that you own, everything that you feel is an asset. A lot of times people think assets is a bank accounts and life insurance policies and houses or cars. But some of your precious assets could be your heirlooms. Some people collect photographs. You can have photographs back from when your great grandmother. And wouldn't you want those photographs to be preserved? What about your jewelry? What about some of the paintings you have? And the last thing you want to do is to have your children fighting or your heirs fighting over who gets what, when simply you could just put it on a piece of paper. You can sign it at the bottom, and that pretty much in the state of Pennsylvania can stand in a court of law, or stand to be approved by me if you can approve that that was the signature of the testator. But what we encourage you all to do is to go to an attorney, because attorney, particularly a state will and estate attorney, so they could actually answer some of the questions and give you some of the details legally that you may not understand. So one of the things that people don't know is the Register of Wills is not a city office. It is a state office, and we are an agency under the First Judicial District of Pennsylvania. So our mission is to preside over the protection of your generational wealth. So I act as the security. And last year we sent in estate taxes between 80 and $100 million. Well, last year we sent like around 80 million, but every year we send between 80 and 100 million. We are normally number one out of all the counties in amount that we send to Harrisburg. We go 1 and 2 with Montgomery County. We're a first class city. So when people want to suggest like much that you see in the news about Philadelphia is crime and, row houses, it's not empty lots. No, we actually have a lot of property and a lot of wealth here in the state of Pennsylvania. And I think that that is important for you all to know, that this office have been serving the citizens of Philadelphia since the 1600s, way before the Revolutionary War. And so if it existed in the 1600s, I feel as though that it is my responsibility as the Registrar of Wills to go out and let you know what we do. And State Representative Isaacson told you much of what we do, validate wills and probate them, whether you leave one or not. Of course, we collect the inheritance taxes. I assign executive privileges. And a lot of you all don't know that we have one of the oldest collections of archives in the history of this country. We have William Penn will. We have Benjamin Franklin will is out on loan to the Franklin Institute. We have John Rittenhouse will. We have wills and archives that date back to the 1600s. So we preserve those documents, and we are currently in the planning process of preserving those and digitizing them, because many of you all don't know that recently, when they had the rebellion and the protests, every last one of our windows was broken out by the rioters in City Hall. And we had a little Starbucks right there on Dilworth Plaza that was burnt down to the ground. So if that Molotov cocktail had hit the Register of Wills, we could stand to lose some very precious documents that we wouldn't be able to replace. And so that's one of my primary agendas, besides educating you all on about all the services that we offer. But also I wanted to make sure that we preserve history. And so before we start talking about wills, I want to let you all know that despite the fact that City Hall is closed, the Register of Wills is open, and we are open to the public, and we are open to the public by appointment only. And unfortunately, it's by appointment only because we had to restructure our offices so that when you come in, they will be COVID safe. So our employees would be safe, but also as important, when you come in, you would be safe as well. So I want you all to know that we are open. We never closed during COVID. We realized as a team that we couldn't afford to close down. Why? Because if we understood or understand the importance of essential workers to be out there on the front line, such as our police force and our fire force, then I had to make sure that people had the ability to marry. So we created virtual marrying. And we were the only city, and I believe the only city on the East Coast that were doing virtual marriages. And that was over the video through what we call the Quaker marriage. And that was successful. We married thousands of people. We now are open for the regular marriage licenses, and we will put information up on the board so you'll know how to contact us in regards to if you want to, one, get married, because the Register of Wills also issue marriage licenses, and we also preserve the record. So if you need records for your real ID, we are open to the public for that. We have a hotline that you can call. We'll put that up as well. And we also now have an updated webpage. So any information that you do not understand through this short webinar, you can go on phila.gov/wills, and you can see all our information and all the contacts that you need to know. You can download, and you can do basically much of your stuff from home. And then we scheduled an appointment, and we are even doing citation hearings. I did my first one online. So we're trying to minimize your exposure outside as much as possible, at the same time protecting my employees. Another thing that I wanted you all to know before we get to the nitty-gritty of this presentation is we probated wills, because of course people were dying, and people were dying that had stocks, bonds. They were in the middle of buying houses or selling houses. And so we continue to probate and have our office open for that. Unfortunately, we had to only have it open through lawyers because of the time and the exposure. But now we're open for a pro se. In other words, you can come in and probate, just make an appointment with us. So let's talk about a will. Let's just talk about the nitty-gritty of a will. I know sometimes I don't really hear that conversation a lot. I know certainly when I purchased my home, I was a single parent with 4 children, and I never understood the importance of wills until I started as a community activist, and I would bring out information about basic system repairs, and I would inform the constituents in my community about this grant money that you could get in order to assist you with basic repairs like plumbing, electric, roofing, cement, even installing, making your house senior proof. And I don't know the correct term for it, but you know, when you become older, you may need the railings to get up and down the step. And a lot of these programs were coming through offices like the council and the state reps. And we would let people know, hey, there's not a waiting list. And many of the people who were eligible or thought they were eligible found out they weren't eligible because they were living in a house that had a deed in a deceased relative name. And so a lot of times people think they live in heir property, and there's no such, it's not even a legal term. And they are living as pretty much, you could say, as squatters, because you don't have any legal rights to that house and you can't do legal transactions. And the state rep mentioned a few of those, but let me just add a couple more that's very important. You can't get homeowners insurance. And when you live in a row house, one of the most important things that you need to have, and the banks will make you have that when you have a mortgage, is homeowners insurance, because just in case there is a fire next door or even in your house, you want to be able to have insurance so it can protect you and protect your asset, because not many of us are able to be self-insured, to be able to rebuild the home along with everything that's in the home by way of what we make weekly or bi-weekly from wages. And so you can't get homeowners insurance because that house is still in dead grandma and dead grandpa name. I recently found out when my daughter went to do some public service work in Puerto Rico that they could not even get FEMA. Now, FEMA is government subsidies. It's the difference between insurance. You pay for insurance and you get the subsidy. FEMA is when the government bails you out when it's catastrophic loss. I just was looking at TV just recently, and poor Louisiana is getting ready to get hit with another hurricane. Now, imagine if any of those residents are living in homes that are still in dead uncle's name, their aunt name. They won't qualify for FEMA, which is a government subsidy that all citizens deserve. But because of a legal technicality of not leaving a will and testament, this is causing a lot of problems in Philadelphia, and it's resulting in people, one, losing homes because they can't afford to maintain it. They can't afford to rebuild because the house was in the dead aunt or dead relative's name. Another problem that I'm seeing is people verbally say what they want to happen with their assets. And I'm here to tell you, in the state of Pennsylvania, we have to follow that constitution. And if a verbal will does not count, if it's not in writing, it does not count. And if it's not in writing with a signature at the bottom, it does not count. You don't have to have you do not have to have witnesses, and you do not have to have it notarized. So for those who can't get out the house or think they can't afford an attorney, right now, you can actually write down your assets, and then on another side, say who you want those assets to go to, and then you sign it. But you must tell someone where your will is, because in the state of Pennsylvania, unlike the state of Maryland, where when you make a will, you go and register it at the Register of Wills in Maryland. In Pennsylvania, you do not register the will. We do not see that will until you die. And so make sure that you let somebody that you trust know where your will is. Make sure you know, make sure that will, and I will stress, don't think if you can't afford an attorney, there are numerous free will clinics, and we will provide that to the state rep so she can actually give you that information about the organizations that assist people in making wills. We have organizations that assist you into coming out of those tangled titles. And this is for people that fall under the income line where they really can't afford it. And so it's simply, a will is simply a document you write down during your lifetime that distributes your assets. Your will is not effective until you die. We do not store the will. You need to put the will up in a safe place, and you need to let someone know. When you have your lawyer make your will, remember to let this attorney know that you want a self-proven affidavit. And that is a sworn statement used to acknowledge and verify under the oath the witnesses that viewed the testator signing of the will. In other words, when you make a will, there are two witnesses that sign off. If you ask for the self-proven affidavit, that means when your heirs or whoever is the executor over your estate come to our office, they don't have to track down those witnesses without a self-proven affidavit. And many times some attorneys don't remember or don't know that a self-proven affidavit will protect you even more, so your heirs won't have to go track down the witnesses who, one, may have died, may have moved, may be uncooperative, and it makes it all more difficult for us to be able to transfer that wealth to the heirs that the testator wants that particular, those assets to go to. And so the best practice is to have two people witness your will and to have it notarized. And that's what attorneys will do for you. And I would say go to a will and estate attorney, because sometimes you have complicated situations and you do not want to leave complicated situations, because I have had the privilege of sitting in some of the hearings of, because when you had a will, I don't even have to see them. They go through the process. They're in and out. They had their paperwork, and then we process it, and you pay. They pay the debt, assets, and then they go pay the estate taxes. Without the will, then they're going to have a citation hearing and come in front of me, and then they're going to have to, show proof of heirs, show proof of fight over who's going to be the executor or executrix of the estate. And I'm telling you, State Rep, hopefully one day, maybe you will join us one day. It is some of the most saddest situations that I see. You talking about once you die and you think, oh, they're gonna be kumbaya, everybody's like,
Nope.
No. I've seen siblings like almost not speaking, hating each other, screaming, breaking down, crying. I've seen grandkids who everybody knew that Grandma Mary said that she wanted granddaughter Mary Ann to inherit the house. She raised her. She wanted the granddaughter to have the house. Everybody knew it. The granddaughter lived there. The granddaughter took care of her. The granddaughter took all the businesses, but Grandma Mary didn't make the will. She didn't put it in writing. And guess what? Grandma Mary had 4 or 5 kids or 2 kids that simply said, yeah, you can have the house if you buy us out, because then they become the direct heirs based on intestate, based on the laws of the state of Pennsylvania. So either you want to make that decision because that is your assets and that is the way you want it, or you're going to leave it to the state to make that decision. Which one do you want to do? I have my solicitor on, Sharon Wilson, and I wanted to let you all know that I am not an attorney. I'm just the administrator with Register of Wills, but sometimes she chimes in And I encourage her to chime in to, go over anything that she felt that I might have missed on the importance of making wills before we move on.
I don't think you missed anything, Register, on the importance of making a will. I think you talked about it all. How we want to transfer our assets to the people that we love most. How sometimes assets aren't just financial things, they may be sentimental things. How the lack of a will can also contribute to a very disruptive family dynamic as people try to work out on their own, what you really should have left them for in terms of guidance, that you should have left them a will. So I don't think you missed anything, but there is one other thing that I do want to say. Earlier, when you talked about the fact that the Register of Wills office remained open during a time of COVID in order so that people could marry, I just want the public to know it wasn't because you're a big time romantic, although you might be, but it
I
was
am.
also because during the time of COVID, people needed their health benefits. And that there were people who had intended to get married or maybe were going to get married later, but needed their health benefits now because they needed them to counteract the effects of this disease or maybe some other disease, but that they weren't able to deal with because they didn't have the health benefits that they thought they were going to have, or because they had to get a transfer of assets from one person to the other who might be in a very ill state. So allowing people to marry, it may seem like it's not a very important thing, but during the pandemic, we discovered early on that it was an important thing. And so the register took steps to make sure that it happened.
And I have to give much of the credit to my staff because the pandemic came within right before my 100 days of office. So I only was in office for 60 days. And so we had to figure out, and we did it within a week. Terry was part of, Attorney Booker was part of the process. And it was really scary. And this is a lesson for all of us. This pandemic, we can look at it in many ways. And one of the ways that I want you all to look at it is that it's important to plan your estate. So I want to encourage, and I see that on your platform, State Rep is education. And yes, relevant education. This is the kind of information that should be taught in high school. You should not learn this on the fly. You should not learn this when something happens tragically and then you're looking to add. I hear funeral directors telling me people are asking them, you know, what do I do? I need to get some money. I don't have money. I need money to pay you for this funeral. And one of the problems that we're finding with the Banking Association, which I hope to one day sit down with them, is they aren't educating their tellers and staff that when a person dies and they have a bank account and their heirs need to get access to that bank account, they go to the bank, of course, because they see the bank statement, they go to the bank and they try to withdraw the money because oftentimes, you know, you might need that money before the life insurance policy come in, or you might just need the money to pay the mortgage or pay utility bills or something. And a lot of times they will tell them that they need to come to us to get a short certificate. And yes, that's true, but no, that's also not true. You can access a deceased relative's bank account if they have $10,000 or less in their account. If you show proof of relation, meaning a parent, a spouse, siblings, brothers, siblings, and you come and bring the death certificate and the funeral bill. If it's $10,000 or less in that account, they have to release it to you. A lot of times the banks don't know that. And then they come to us for a short certificate and we send them back, or we will call the bank. I've had my deputies call the bank and tell them and recite the statute to them. because I think they still think it's 2,500, but state rep is now 10,000. Now, if you have $10,000 and one cent or more in there, yes, you would have to come and get a short certificate, which means you would have to probate the estate as well. But people need to understand that, because when people die, it's really during like a sort of crisis, and you may not have the money, and you may need to go to their bank account just to get basic things like paying for the funeral. So that's just a sidebar that I think that we want to educate people more about, because it's becoming a problem and an issue. Because what I'm thinking is that I don't think that that's one of the top priorities that the executives of these banks are educating people about, and it's causing a lot of confusion. And so they come to us and we are solving the problem. But I think that we need to go higher and a higher level to let them know, so they can educate people, so people won't, because they're losing time. And so let's go on to deeds and what a deed is. A deed is basically a legal document that confirms a person's ownership of property. In other words, the person has title to the property. Like, that house is in this person's name. And in this case, let's talk about it being in the deceased person's name. And so one of the misconceptions that Philadelphians have is they think they can come to us to get the deed transferred. And no, our office we have nothing to do with the deeds. We do the probate, we do everything to get you to the Office of Deeds. And right now, I think, and Terry, correct me if I'm wrong, City Hall is closed to the public, period. Is the Department of Deeds, are they open at least for, are they open or are they still closed?
They are open. They are accepting deeds and things on, via mail and email and things like that.
Okay, so I just wanted to let you all know the Register of Wills have nothing to do with, Register of Wills has nothing to do with the deeds. So let's talk about the personal representative, or the person that is named in the will or appointed by the Register of Wills, either or. Either you're going to name your executive in your will who you want to divide your property and also pay the debt. People don't know that. It's important. They get to divide those assets, but they still have to pay the debt. That is the responsibility of the representative or the administrator or the executive. You want to name that person, because if you don't leave a will and name that person, they come to me and I have to decide who is going to be fair and who that I trust is going to act professional, be transparent. Because a lot of times the administrators think that they don't have to account to the heirs, even if they're one of the heirs. And I, was talking with one of our judges, and he emphasized that, that's something that we should emphasize, and something that you all should know, that the person that you are going to lead or appoint to be your administrator or your executive over your estate, please make sure that person understands that that is their role, and their role is not to spend the money, or they make the best decisions. But sometimes what I found with a lot of the executives is they feel that they don't have to account to the heirs. They don't have to tell the heirs what they're doing with the estate, because a lot of times the heirs will come, and I'm sitting in these citations, and they'll simply say to me, the executor, who could possibly be the sister or the uncle or the aunt, or even sometimes the lawyer, is not being transparent, letting us know exactly what's going on. So how much are you selling the house for? And who's buying it? Just basic things that I emphasize when I decide, because sometimes the fighting is so contentious amongst the heirs or the siblings that sometimes I have to make the decision to appoint an attorney to be the executor, just so, this fighting and this disruption. And if anything, I know you all love your loved ones. I love my loved ones, but you all know the person in your family who you trust that is going to be fair, transparent, and minimize the confusion. And you know the one that you love to death that may be a problem. And even if you love them, please don't leave that problem when you die onto your other heirs, because it gets ugly and it's unnecessary. You have the right, the responsibility to determine who inherits your assets and who administrates to make sure all your debt is paid, make sure your inheritance tax is paid, and whatever is left is divided the way you wish, and not the way the state of Pennsylvania intestate will distribute it. Because we do have to follow the letter of the law. And I'm telling you, I keep a box of Kleenex in that hearing room, because the boo-hooing, and you could tell that these people are not making it up. They really believed that the mother or the deceased person really wanted them to have this or that. But because you didn't put it in writing, we have to follow the letter of the law. And sometimes I have to use discretion and authority to say, listen, this battling will never settle this estate. So now let me appoint an attorney, and thank God that I have Sharon as my solicitor, who's has decades of experience. So she knows, uh, the attorneys that would be fair and honest. And also I'm working with the Bar Association as well. So let's talk about inheritance tax, because a lot of times I hear people say that they don't want to probate or change the name out of the deceased person because they don't want to pay inheritance taxes. And a lot of times they think that it's a lot. And sometimes it is, depending on how big the estate is. But remember, the estate is taxed on when the person died. So say, for instance, your grandmother died in 1970. So the value of the house in 1970 is different from what the value is now. So you will be taxed on what the value was in 1970. And so for this portion of our webinar, our attorney Sharon will give you some best practices on inheritance and estate taxes.
Okay, Register, I'd be happy to. Listen, inheritance tax is just a transfer tax that you pay upon death. So whenever an asset is transferred, because a death occurred, inheritance tax is owed. Now, it's possible, like we talked about some of the real property being in the name of a deceased, it's possible that you decide not to change the deed into the proper person's name, but that doesn't mean that the inheritance tax isn't applied and doesn't continue to run. You pay the tax based on the relationship of the person that died to the person who's actually receiving the property. So for example, if a spouse died and transferred property to their husband or to their wife, they pay zero tax in Pennsylvania at this current time. If a sibling died, they might pay 15% in tax at this time. So the closer the relationship is, the less the tax will be. Now, once we establish the relationship and establish the tax, you have to pay that tax within 9 months of the date of death. After that point, interest begins to run. So while the tax isn't a particularly large tax to begin with, as interest accumulates, it can become very burdensome to pay the tax. If we're talking about paying tax on someone who died in 1970, that could be a substantial amount of tax and a real barrier to, at that point, getting that real property in your name. So the lesson to take from this is one, get the tax assessed. Two, figure out which tax you have to pay and start to pay it. Because the Pennsylvania Department of Revenue will give you a payment plan. So don't think that if you can't pay it all, you don't have to pay any of it. And the tax doesn't go away just because you decide not to pay it. If you go to sell your house, it's there. If you try to refinance that property, it's still there. So it's a lien against your house if you don't pay it. And they won't allow you the freedom of doing what you want with your property until that tax, in fact, is paid off. And it's just one other thing I'd like to mention, Madam Register, earlier when you were talking about the will and some of those really tragic situations that you've seen. Listen, you may like the register, you may like her very much, but why would you allow anyone other than yourself to decide who's going to administrate your estate? You may like any attorney very much, but why would you allow that attorney to become the administrator of your estate when you know there might be a family member that could be a better person? We haven't talked about it yet, but often they do ask us what happens if you decide that you don't have a will. Well, Pennsylvania has laws on the books that decides who will inherit your assets in the event that you don't write it down. So the person who actually gets your asset may not be the one that you want to have the asset. So those are two good reasons for making those decisions yourself. I know you want to get on the tangled titles, so I'm not going to take up any more time, but I just wanted to mention that.
Let's briefly talk about the tangled title. According to some statistics that I got from the Pew Institute and also from Philadelphia VIP, which is one of the leading philanthropic law firms that is helping people with the tangled title, they estimate we have between 14 to 18,000 tangled titles or homes that are in deceased people names. And I beg to differ. I think there's a lot more. And if we're sitting in our homes right now without wills, those are some potential tangled titles. So we are in a crisis. And I want to sit down with some legislators so we can address that, especially with the increase of gentrification, the increase of rent, available housing, available affordable housing, and the risk you have when you allow a house to fester in a dead person name, which at this point right now, especially with COVID-19, we're seeing an awful lot of homeless people and people are losing jobs. And a lot of times, if you're living in a house that's in a deceased person name, the house pretty much is paid off or should be. And hopefully maybe the taxes aren't backed up on it. But so a tangled title simply is a house that you believe that you have legal interest in because it was your grandmother's, your aunts, your uncle, somebody promised to it. You've been living there, you've been preserving it, you've been taking care of it, your kids. And I've had people call back 4 and 5 generations that are sitting there saying, what do I do before we lose this home? And so we started a program called the Probate Deferment Initiative. And the reason why we had to defer, or we're going to defer fees for people that fall under a certain income bracket, because we're going to help you get out of these single titles, is because of the state law in Pennsylvania. They set the fees and the registrar of will cannot waive fees. We can defer them, however, we just can't waive them. And Attorney Terry Booker has assisted me along with the Bar Association and a host of other organizations like Philadelphia VIP, Community Legal Service, Christian Legal Service, to help us come up with a program that can assist some of your constituents, State Rep, with the help of helping them get out of their tangled titles. And the biggest issue was they couldn't afford the fees. And so, Terry, can you briefly talk to this audience about the probate deferred initiative? So we'll have more information about it, and we will be able to steer you to the organizations that will interview you to determine your eligibility, so you can begin the process of getting raising these estates, so you can get the house in your name, so you can conduct business.
Yes, so the probate deferment initiative is designed to help those who may not have the upfront money to pay the probate fees for a tangled title. So in some cases, there may be 2 or 3 estates that need to be open. And for some people, $700 to open up an estate is a lot of money. And if they can't afford to pay those fees, we are going to defer them. We are going to place a lien on the property within the estate until they are able to pay those fees. But if they decide to stay in the house, we're not coming after you for the fees. We'll just let you stay there until you decide to sell it. If you decide to sell it, that's when we're going to say, hey, you have your money, now give us our money, please. So that anyone, if you are in a situation where you don't, your name is not on the deed to your house, and you are not able to afford to pay the probate fees, we are suggesting that you see the Christian legal clinics, the CLSs, Philadelphia VIP, Community Legal Services, CLS, I'm sorry, for all those abbreviations. And those agencies will get in contact with us, and they will help you through the process of filling out an application for the probate deferment initiative. And you'll go through the probate process as usual, which Madam Register already talked about, opening your estate and things like that. And then your fee will be deferred, as I stated, once you're accepted into the program.
Yeah, and so I am delighted about that. And State Rep, we will be sending you that information. We are going to announce a call to action. We wanted to try to recruit as many attorneys as we can to volunteer to help with this process, because there are so many people that are in this predicament. I'm sure they've came to your office, and we want you to, any of your workers or your staff members that have any of your constituents that you think qualify for this particular program, we will have the information, and we're going to send it to you as well as the rest of the state reps as soon as possible. But I felt that was one of the things that I campaigned on, because I am very concerned about people being able to save their homes at a time like this. We have a lot of single heads of the households. We have a lot of households that have children that are disabled. We have elderly people that are in houses that they inherited, that they need assistance. They need to get basic system repairs. And I think that if government don't do something, don't do something to assist our citizens, then I mean, it's going to cost us in the end. And it's not even all that, well, it is about money because that's our taxes, but just the humanity of someone who grew up in a house that their grandmother had, and they're now seniors, and they want to stay in their home, and simply because of technicality, because we weren't financially literate enough to understand the importance of taking care of business before we died. And so that is one of my strongest initiatives that I would like to partner with you. And in closing, Sharon, I think, we covered everything. We normally have a Q&A. We have questions that people always answer. Can you look on that paper, Sharon, maybe 2 or 3 questions that we can share with them that we may have missed in our lecture that you think would
Sure.
be beneficial, please?
I'd be happy to. One of the questions people ask often is about, well, transferring through a deed. Will inheritance tax be payable if I do it that way? Trying to get around from paying the inheritance tax. Remember, the inheritance taxes are transferred from one death to another person. So initially, if you add somebody on your deed, there won't be any inheritance tax payable because nobody has died. But when somebody dies, and you accumulate a greater percentage of the property. So maybe initially it's 50-50 on the deed. And then when somebody dies, you now accumulating 100%. Yes, if you get a percentage of that property by virtue of death, then there would be an inheritance tax payable, even though it happens automatically. And at some point, somebody will ask, well, has an inheritance tax return been filed and paid in this case? And usually that point comes up at the time that you sell the house or try to remortgage the house or get insurance on the house. So you should still be mindful of what happens in that scenario as well. Now, another scenario that people asked us about is, if I have a trust, do I need to still draft a will? And my answer to you is yes. A trust can do many things. And one of the things that people do enjoy about a trust that's different from a will is that there's a certain air of privacy to a trust. You don't have to publicly file it when somebody dies. But I will tell you that if there's a dispute, then it becomes a public document when you go to court. So don't, fall into the pit of thinking that it will always be private, because that may not be the case. But what a trust will not do is it will not clean up all of the things that you might have left behind in that trust. All of the things that you may own, but for whatever reason weren't designated in the trust. A trust will only apply to those things that you have actually listed in the trust. A will has the ability to provide a clause that says something that to the effect of, it's called the residue clause. Anything else out there that I forgot about, that that I haven't sort of made a count of, this is what I want you to do with those things, which can be very important. And not to mention that trusts are generally more expensive than wills. Generally, you will find, in my experience, that a living trust will cost you maybe about 3 times the cost of a simple will. So you need reasons to formulate a trust. A trust is when you give somebody something, but there are conditions. So you should have a reason for giving somebody something with conditions as opposed to giving it to them outright. And the last thing that I'll say about a trust is in regard to real property. When you receive property in a will, by virtue of death in a will, the law allows you to have something called a step up in basis. That means the law allows you to treat that property as though you paid for it what it's worth on the date of that death. Being able to do that can radically reduce the amount of tax that will be due if you decide to sell the real estate. So if you transfer the property to the trust on lifetime, you may miss that step up in basis. So That sounds a little bit complicated, but it's not really. What I want you to take away is that you need to think about what the consequences are of transferring something in trust as opposed to transferring it via a will. Anything else you'd like me to specifically talk about, Representative?
No, I think you covered all the bases.
Thank
Yeah.
you.
This has been extremely informative. And yes, my office definitely has constituents that come in who don't know what their rights are and have, you know, obviously issues with family members. And, you know, I have a lot of, as you know, in the historic district, so I have a lot of the older areas of the
Mhm.
city, and, you know, properties are passed down just by having somebody put on a deed, and they don't know the ramifications of dealing with the paperwork and the settling the estates. So your office is very helpful with that, and I truly appreciate it. And this has been very informative, and thank you for reaching out.
Yeah, and I had looked over your district, and I wanted to um, say that a lot of times people think that rich people have it all together and have wills. I'm finding that rich, middle class, a lot of people just simply don't have a will. They say, I'm getting around to it, or it's just across the spectrum that people, not that they don't understand the importance of it, but you don't know what it is, the superstition, or just the fact that you're just not financially literate. But I just want to say that a will is definitely a critical asset to protect your wealth. And my office is open if you want to contact us. We're at Row Online at phila.gov. We 215-686-6250. We answer the phones from 9 to 3. And if you call after that, we have for the first time an answering machine, and we answer everybody's calls. And if you email us at rowonline at phila.gov, we will email you back. And State Rep, you can call me personally. Tasha will give you my cell phone number, and just send me the name of the person and their phone number, and we will contact personally any of your constituents, because people are really scared. A lot of times people, okay, we understand sometimes it's pure innocent ignorance, but sometimes people are really scared, and you're scared to open the envelope to see that I know I'm going into foreclosure. I'm not going to open this envelope. Or I don't want to talk about this, or I don't want to deal with this. But the more that you keep it in that dead person name, generation after generation after generation, you're going to have to open up estates. And we have a program here, the probate deferment initiative, that we are deferring it. As long as your family stay in that house, you don't have to worry about those fees. We only want them if you sell the property. And we are open for any questions you have, State Rep, any questions that your constituents have. And I am so honored to be able to serve you all. And I want you to all to go to our Facebook page, our Twitter page. We also have an Instagram page. We put up different best practices on there on a daily basis, and tell your friends about it and talk about it. And don't be afraid to talk to your mother, your grandmother. It's a conversation that is uncomfortable, but it's necessary so you can protect your generational wealth. Or so you can, when you come to me, I want you to know that I will serve you and serve your best interests. Thank you all. Thank you, State Rep Mary Isaacson. I hope that we have another one of these webinars, and when we're in better times, I would love to do a open face-to-face. But I like the virtual. I mean, I don't, Grandma Mary don't have to get up and make us drive her to the police station or to the recreation center. We can just simply do this. So we have to encourage our young people to help our seniors get on these webinars. Like, they can take their laptop over there or their smartphone and dial up the Zoom and hold it so grandma can hear things like this. Thank you all, and I appreciate you.
Thank you, and have a great night.